Hello, everybody. Welcome back to our next kind of topic as we move through our courts related content. So today we're talking about, what happens after you've been arraigned, and let's say you decided to plead not guilty. So we're assuming, you're proceeding in the direction of potentially going to trial, right? So for that to happen, we have to select a jury, and during this process, the prosecutor and the defense attorney are also going to engage in plea bargaining to try to forego a trial, try to, get the case closed and come to a conclusion more quickly than a trial would take. So let's dive into how we actually get from a community of millions to a jury of 12. The jury selection process is designed to be both random and representative, but as we'll see, there are several steps involved. So the foundational principle here is that juries should represent a cross-section of the community. This isn't just a nice idea, it's constitutionally required. The Supreme Court has consistently held that jury pools must be drawn from a fair cross-section of the community. But here's the key point. We start with the entire community and systemically narrow it down. So the process begins with what we call source lists, or like a big old list of potential jurors. So most jurisdictions use voter registration and driver's license databases because they're comprehensive and regularly updated. So some states also include tax rolls or ID card databases to create their big list of potential jurors. And then the computer randomly selects names. There's no human discretion at this stage. You might get a jury summons whether you're a CEO, a student, or a retiree. The randomness is crucial for the legitimacy of the process. Not everyone who gets summoned will or can serve. There are basic legal requirements. So you must live in the jurisdiction that the case is presiding in. You have to be a U.S. citizen. You have to be at least 18, and you have to have no disqualifying felony convictions. Some states also require English proficiency. These aren't arbitrary requirements. They're designed to ensure jurors can understand the proceedings and haven't had their civic rights suspended due to serious criminal conduct. Once qualified, potential jurors are divided into panels, usually 20 to 30 people per panel, and assigned to specific courtrooms. This is where the real selection begins. So that then brings us kind of to our next topic, which is voir dire. So this is a French term meaning to speak the truth. This is where the theoretical process of jury selection meets the practical reality of identifying who can actually be fair and impartial. It's arguably the most critical phase because this is where we separate those who can truly judge based on evidence from those who cannot. Voir dire typically starts with the judge asking basic questions to the entire panel. So, do any of you know the parties involved? Have you heard about this case in the media? Do you have any religious or moral beliefs that would prevent you from serving? But then it gets more specific. In many jurisdictions, attorneys get to question jurors directly, and this is where it gets interesting. So let me give you a concrete example. In a DUI case, attorneys might ask, have you or anyone close to you been affected by drunk driving? And if the potential juror's spouse was killed by a drunk driver, they're not necessarily disqualified, but the attorney needs to know if they can set aside that experience and judge this particular case fairly. The goal isn't to find people with no opinions or experiences. That's impossible. It's to find people who can acknowledge their experiences but still be impartial. The art of voir dire is asking the right questions to uncover hidden biases. Some biases are obvious. If you're related to the defendant, you're out. But others are more subtle. So in a medical malpractice case, you might ask, do you have strong feelings about frivolous lawsuits? Or have you ever had a negative experience with a doctor that might affect your judgment? And here's what's fascinating. Research shows that people often don't recognize their own biases. A potential juror might genuinely believe that they can be fair, but their life experiences create unconscious leanings. That's why it's good, why good attorneys ask follow-up questions. So they might say, "You mentioned you think there are too many lawsuits. Can you explain what you mean by that?" The goal is to get people talking so their real attitudes come out. There's also something called social desirability bias. People want to give the right answer rather than the honest answer. They might say they can be fair when they really can't because they want to be seen as good citizens. Skilled attorneys can learn to read between the lines. After all the questioning comes the challenge phase, which brings us to our kind of next slide. But here's what's important before we get to that to understand. The jury you end up with might look very different from the initial panel. In high-profile cases, you might start with 50 to 60 potential jurors and end up eliminating 75% of them. The 12 people who finally get sworn in represent those who survived, not just the qualification process, but also the intensive questioning and challenge process. They're not necessarily the best jurors, but they're the ones both sides believe can be reasonably fair. So after coming up in the process as they're being questioned, this is where jury selection kind of becomes a strategic battle. So both sides have tools to remove jurors they don't want, but the rules governing these tools are very different and create some of the most contentious moments in the courtroom. So challenges for cause are this unlimited tool, but there's a catch. You have to convince the judge there's a specific articulable reason why this juror cannot be fair. The standard is quite high. It's not enough to say, "I think this person doesn't like my client." You need to show actual bias or inability to follow the law. Classic examples include a juror who says anyone charged with a crime is probably guilty, or someone who admits they could never impose the death penalty in the capital case, or a police officer's spouse in a case where police credibility is central. But here's the key. Even if someone has a relevant experience, like being a crime victim, they're not automatically disqualified. The question is whether they can set that experience aside, like we discussed before, and judge this case on its own merits. Judges are often conservative about granting these challenges because they don't want to create grounds for appeal. So they'd rather err on the side of keeping someone questionable than risk having the verdict overturned later. Peremptory challenges are the attorney's kind of gut feeling tool. You get a limited number, typically anywhere in the state of Texas, it's anywhere between like 3 in misdemeanor cases to 15 in capital cases where the death penalty is on the table per side. So 3 to 15 for the defense and 3 to 15 for the prosecution. And obviously that depends on the case. You can use them to remove anyone without giving a reason. This is where jury selection becomes kind of an art. It's like part art, part science, and a little bit psychology. So attorneys develop theories about what kind of juror will be favorable to their case. Defense attorneys in a corporate lawsuit might prefer younger jurors who are skeptical of big businesses, while prosecutors might prefer older jurors who they believe are more like law and order oriented. But here's the reality. These stereotypes are often wrong, and good attorneys focus more on individual attitudes than demographics. The catch is that you can't use peremptory challenges in a discriminatory way. So you can't remove someone simply because they're Black, Hispanic, female, or male. But you can remove them because they're a teacher, or because they seem hostile, or because they gave answers that concern you. All of those are reasons you could remove them using your peremptory challenge. The tension between these two types of challenges gets to the heart of what we want in a jury system. Challenges for cause protect the integrity of the process. We don't want obviously biased jurors, but peremptory challenges serve a different purpose. They give both sides confidence that they've had a fair shot at seating a jury they can live with. But this brings us to Batson challenges, named after the 1986 Supreme Court case Batson versus Kentucky. So here's how those work. If one side thinks the other is using peremptory challenges in a racially discriminatory way, they can object to that peremptory challenge. The judge then requires the challenging attorney to give a race-neutral explanation for their strike. So, for example, if a prosecutor strikes 3 black jurors in a row, the defense can raise a Batson challenge. The prosecutor might then have to explain, I struck juror number 3 because she said she distrusts the police, juror number 7 because he seemed evasive in his answers, and juror number 12 because she works as a social worker and might be too sympathetic to defendants. The judge decides whether these are legitimate reasons for or pretexts for discrimination. This is where jury selection gets kind of really complex, because the line between legitimate strategic thinking and improper discrimination can be very thin. The system tries to balance giving attorneys meaningful input into jury selection while preventing the exclusion of entire groups based on gender or race. What emerges from this process is a jury that both sides have had a hand in shaping, but neither side completely controls. It's a compromise that reflects our adversarial system, the idea that truth emerges from the competition between opposing viewpoints, starting with who gets to decide the case. You might be wondering, why do we go through all of this elaborate process? Why not just pick the first 12 people who show up? The answer goes to the heart of our constitutional system and the legitimacy of our courts. The Sixth Amendment doesn't just guarantee a jury trial, it guarantees an impartial jury. The Supreme Court has interpreted this to mean 2 things. Individual jurors must be capable of impartiality, and the jury pool must represent a fair cross-section of the community. This isn't just procedural nicety, it's a fundamental check on government power. An unfair jury selection process can turn a trial into a sham. Let me give you a concrete example of why representation matters. So research shows that all white juries deliberate differently than racially diverse juries. Diverse juries spend more time discussing the facts, make fewer factual errors, and are more likely to correct each other's mistakes. They also consider a broader range of perspectives and experiences. When juries reflect community diversity, their verdicts have greater legitimacy. Both parties and the public are more likely to accept the outcome as being fair. The voir dire process isn't just about finding smart people, it's about identifying and eliminating bias. A juror might be highly educated but completely unsuitable if they've already made up their mind about the case. For example, in a medical malpractice case, a doctor whose best friend was sued for malpractice might be biased, even unconsciously. The challenge system lets both sides remove jurors who can't be fair. There are broader civic benefits too. So jury service is one of the few times Americans from different backgrounds come together and solve problems. It educates citizens about how the legal system actually works, not the Hollywood version. Studies show that people who serve on juries are more positive views or have more positive views of the courts and are more likely to vote and participate in other civic activities. Okay, so now we know how juries are selected. I want to kind of shift our focus and talk about plea bargaining, because while you have pled not guilty and they're doing their jury selection, they might still be working on trying to negotiate a plea deal in the background to forego a trial. So now I want you to think about what you see in movies and TV shows about criminal cases. Usually there's a dramatic trial, it's got passionate closing arguments and a tense jury verdict, right? But here's the reality. 90% of state criminal cases and 97% of federal cases end in plea bargains, not trials. So that means that only about 5 to 6% of criminal cases actually go to trial and are heard by a jury. Plea bargaining isn't the exception, it is the rule. So what exactly is a plea bargain? It's a negotiated agreement where the defendant agrees to plead guilty in exchange for some concession from the prosecutor. This might be reducing charges, so for example, reducing aggravated assault to simple assault or recommending a lighter sentence. The key point is that it's voluntary on both sides. The prosecutor gets a guaranteed conviction without the time and expense of a trial. The defendant gets certainty and usually a better outcome than they might face at trial. Why has plea bargaining become so dominant, though? So first, it's efficient. Our courts simply cannot handle the caseload if everyone were to go to trial. And in many jurisdictions, if even 25% of cases went to trial, their systems would just collapse. Second, it provides certainty for everyone involved. Trials are unpredictable. You never know what a jury will do. A plea bargain gives both sides a known outcome. Third, it allows prosecutors to focus their limited resources on the most serious cases that really need to go to trial. But plea bargaining raises serious concerns, and that biggest concern really is coercion. So here's how that works. Prosecutors can charge defendants with the most serious possible crimes, which carry harsh mandatory minimum sentences. Then they offer a plea to lesser charges with a much lighter sentence. And this creates what we call the trial penalty, which is the gap between what you get if you plead guilty versus what you might get if you go to trial and lose. So for example, a defendant might be offered 2 years if they plead guilty, but face 20 years if they go to trial and are convicted of the original charges. Even if you're innocent, it's an enormous pressure to plead guilty. Studies suggest that some innocent defendants do plead guilty because they can't risk the trial penalty. There's also the issue of pretrial detention. So many defendants can't afford bail, and they sit in jail for months waiting for trial. A plea bargain gets them out immediately, even if they might win at trial eventually. Plea bargaining perfectly illustrates the tension in our system between efficiency and individual rights. It keeps our courts functioning, but critics argue it undermines the right to trial that we just spent time discussing. And it's a system that works in many ways, but at what cost? So this is what I would challenge you to consider, think about. And that is all that I have for you in this video, and we will, in our next one, be discussing the kind of trial process and what that looks like.